So we are talking about redundancy and restructuring in the higher education sector. I should say that I can see from our attendee list that we might have some of you that are from institutions other than higher education institutions. Hopefully the principles that we talk about this morning will still be useful to you. But we're talking specifically about redundancy and restructuring in the higher education sector because it's something that Judy and I and our colleagues, specialist employment lawyers for education sector clients, it's something that we're talking to everyone about a lot at the moment because it seems to be coming up time and time again in a cost-saving context. We know that you're in a particularly challenging financial climate at the moment, as are a lot of organisations. But I think there are a number of things which are unique to higher education institutions at the moment, challenging recruitment, both domestically and internationally, changing immigration rules, which is having an impact on that, an uncertain political climate, and also the rising cost of running an organisation that's being felt by a lot of institutions, but also against the backdrop of relatively unchanged tuition fees over the course of the last decade or so. So all of those factors are having an impact in terms of cost savings that institutions are seeking to achieve. And that's also coming down in terms of the savings that institutions are seeking to achieve from a payroll perspective as well. So we're finding that perhaps more so than over the last few years, institutions are looking at running redundancy and restructuring exercises. So Judy and I are going to take you through 5 key considerations in the running of those exercises. Now, as I said at the beginning, this session is due to last for half an hour or so. So hopefully a relatively quick burst of information for you before you get on with the rest of your day. And we're going to be looking at broad themes and best practice, along with some recent updates as well. So hopefully nothing too technical for you this morning, but things to bear in mind if you're either running or thinking of running a redundancy or restructuring exercise in the near future. So these are the 5 key points that we're going to be looking at. So I'm going to start off by looking at voluntary severance and voluntary redundancy. Judy's then going to talk about redundancy consultation and some key updates on that. I'm going to then talk a bit about internal policies. Judy's going to move on to talk about equality considerations, and then I'm going to finish off by talking about trade union considerations before we come to any questions if we've got time. So starting off with voluntary redundancy and voluntary severance. And again, from our discussions with institutions, this is something that a lot of you have either run recently or are thinking about running in the context of potential compulsory redundancies and cost saving. And I've put the 2 different terminologies on the slide. And your first question might be, well, what's the difference between those 2 terms? And it can be a bit of a semantics question, and different institutions use different terminologies, and it will vary from case to case. But broadly speaking, we tend to find that when institutions are talking about voluntary severance programs, that's something that you might be thinking of running as part of a general cost-saving exercise before you're at the point of proposing compulsory redundancies. So at the stage that you're looking at voluntary severance, you might not be looking at specific numbers in terms of headcount that you're wanting to reduce, and you're potentially not having proposed or contemplated making compulsory redundancies at that stage. Voluntary redundancy is something that we tend to think of in a much more targeted sense when you're looking at potentially, as I say, looking at reducing headcount by a specific amount, potentially done at the outset of announcing potential compulsory redundancies, or even alongside that process. I've said it in a way which makes it sound like quite a clear distinction, but I'm conscious that sometimes it will be somewhere between the 2. The terminology that you'll use may differ on a case-by-case basis. I think from a presentational perspective, if you're not doing it alongside compulsory redundancies, then voluntary severance can be a more acceptable term, and it can be less of a concern for people if you're not yet at the stage of announcing compulsory redundancies. And the other difference that it can make is in terms of any potential collective consultation obligations. So if you are looking at it in more of a speculative way, where you're not looking at targeted numbers, then you're less likely to have to count those potential terminations in terms of the numbers for collective consultation obligations. Whereas if it is a voluntary redundancy scheme which is being done against the backdrop of specific numbers, compulsory redundancies, then you're much more likely to have to count those volunteers for redundancy within the numbers for collective consultation. And that will, of course, have an impact in terms of the timescales that you're working with, potentially having to consult for a minimum of 30 or 45 days before the first termination takes effect. The other thing that you're going to want to think about in the context of any VS or VR scheme is what terms that you offer. Now, it might be that you have a set policy which dictates a specific formula that you have to use for any VS or VR scheme. Even if you don't have a specific formula or figure written down, it might be that your trade unions argue that anything that you've offered in previous VS or VR rounds is something that you should be offering in the future. And the answer to that will, of course, depend on what was said at the time and how many of those previous schemes that you've run. If you're in a situation where this is perhaps the institution's first VS or VR scheme, then the amount that you offer will need some careful consideration. It will be about striking a balance between offering something which is enticing enough to achieve the number of volunteers that you're looking for, whilst not being so generous that you eradicate any potential savings by the amount that you're paying out. And obviously, as part of that VS or VR scheme, you are also going to want to retain the ability to reject any applications if the business case is such that it doesn't make sense to approve all of them or approve certain of those applications. And then the other point that you'll want to give thought to is whether or not you make entering into settlement agreements a precondition of accepting volunteers for VS or VR. Again, it might be that you have a particular institutional approach to that, but we tend to find that different institutions do different things depending on the exercise. It might be that the numbers involved has an impact on that, where if you've got particularly large numbers, it may not necessarily feel practical to seek to get everyone to enter into settlement agreements. But if it's a particularly contentious exercise, then there may be a benefit to doing so. It may also be that, again, the timescales involved are prohibitive if you're seeking to get it done quite quickly. But a quick point to note on that, which I'm sure you'll all be aware of, which is that you're not able to settle claims for failure to inform and consult where collective consultation is required under a settlement agreement. So that's something that you'll need to bear in mind, even if you are entering into settlement agreements with volunteers for redundancy. Trudy, what do institutions need to think about from a consultation perspective?
Thank you, Abisola. Yes, so my topic for this morning, or my first topic, is redundancy consultation. And in this context, I'm going to mention a recent decision of the Employment Appeal Tribunal, which highlights some key reminders on the requirements of a fair consultation process, which are relevant to employers generally, and also raises a new point on small-scale redundancies. First of all, just by way of recap, as you know, a fair redundancy process will almost always require individual consultation with affected employees. And then in addition, if more than 20 employees in a 90-day period are proposed to be made redundant, then collective consultation requirements are engaged under the relevant legislation. In the case that I'm going to mention, the De Haycox case, the collective consultation requirements were not engaged because it was a very small scale redundancy. Mr. Haycox was selected for redundancy, and at that point, his employer started the consultation process with him. He claimed unfair dismissal, and the EAT concluded that he had indeed been unfairly dismissed because the consultation process with him had started far too late. The AT took the opportunity to give reminders about the fundamental requirements of a consultation process. And these requirements apply to both individual and collective consultation exercises. So first of all, they confirmed that the primary purpose of redundancy consultation is to avoid redundancies and to minimise their impact if there are any redundancies. And in order for that purpose to have a chance of succeeding, it means that consultation has to start at a formative stage. And what that means, in effect, is that consultation has to start when there is still a genuine opportunity for employees to influence the outcome in terms of whether there are going to be redundancies at all or not. So it's at a stage when the employer is still considering whether, in fact, any redundancies will in fact be necessary. The AT also observed that an internal appeal process can't cure or fix fundamental failures in a consultation process, and a failure to start the process at the right time would be one of those fundamental failures. So that's an important reminder, I think, for all of us about the primary purpose of consultation and also when it needs to start. And it also highlights, I think, that it's a tick box approach to consultation, where you start that consultation at a time where employees can't genuinely influence the potential outcome in terms of whether the redundancies or not is likely to run a serious risk of successful legal challenge. So that's the reminder part of the decision. And then in terms of the new suggestion from the Employment Appeal Tribunal that I mentioned, is that the tribunal specifically said that there should be workforce consultation, even where collective consultation is not triggered. So on small scale redundancies or even individual redundancy situations. The AT didn't explain exactly what they meant by workforce consultation, except that it is something that happens when the consultation is taking place at that formative stage. So it's clearly intended to time with the idea that consultation has to address the issue of whether redundancies are going to be required at all. In this particular case, it meant that there should have been wider consultation than just with the employees who'd been selected for redundancy. So the repercussions of this are yet to be seen, but I don't think that this means that in every small-scale redundancy consultation exercise there must be consultation with the wider workforce. What I would suggest to you is if you're dealing with a small-scale consultation process, you should think carefully about whether the people that you are consulting is going wide enough to enable the sort of process that the AT referred to and that I was talking about earlier. So it's really sort of going through that thought process. And if you think that it needs to go a bit wider, you could, for instance, do something like a town hall type meeting where there's an opportunity for feedback. So that is a new development worth being aware of and keeping your eye on. And with that, I think Abisola is going to talk to us about the relevance of internal policies to redundancy restructuring exercises.
Yes, and clearly something that you're going to want to think about at the outset of any redundancy or restructuring exercise is which policies you have that may be relevant and how they impact on that process. Now, it's going to be fairly obvious that any policy which has redundancy or restructuring in the title is going to be relevant. But we do tend to find that a lot of institutions have policies which are A, potentially fairly historic, so drafted quite a long time ago, and B, get less use than your other HR policies. So it may be something which, even if you within the HR team are familiar with, the managers who are undertaking elements of the consultation on the ground may be less familiar with. So it's important to make sure that those policies do get the pre-reading that they need to make sure that they feed into the process and the timescales. And I'll come on to the various elements that you'll want to think about in a moment. The other point is that even if you haven't got a specific redundancy or restructuring policy, there may be other policies or documents internally that are relevant for that process. So, for example, it may be that you have a specific policy on redeployment, which informs certain parts of the redundancy or restructuring exercise, or it may be that your collective agreement or recognition agreement also has certain elements of it which are relevant and prescribe how you will undertake any redundancy or restructuring exercise. I think the key impact that those policies or documents might have is in terms of potential timescales. So what we sometimes see is that even if you're making a relatively small number of people redundant or proposing a relatively small number of redundancies, it might be that your redundancy policy ties you into consulting for a minimum period of time, such as the periods of time that you'd see under collective consultation, even if those numbers aren't achieved. If your policy is particularly historic, it may even refer to slightly longer consultation periods. So that will be something that you need to work into the timescales and the timelines. And it might also be that those policies are prescriptive in terms of certain steps that you have to take before proposing any redundancies, such as for example, operating a voluntary redundancy scheme, as I talked about earlier. And it may also be prescriptive in terms of who needs to be involved in any decision to dismiss, particular committees that need to be involved. All of those things will need to be taken into account in planning that process. And again, it feels like a fairly obvious point to say, but the implications of not following those policies or processes, that it could render any decision to dismiss for reason of redundancy unfair. And whilst it may be that there are certain legal arguments that can be made as to reduce compensation in those cases if the dismissal is otherwise fair, save for not following certain elements of the policy, it's an argument that you'd probably rather not have to have. So to the extent that you're able to do so, making sure that those policies are followed and complied with is obviously a useful and helpful thing to do. It may also be that, again, similar to the point that I made earlier, even if you don't have a specific written policy, there may be certain things that you've done in the past that, for example, your trade unions argue as a matter of custom and practice should be followed in any redundancy round that you're running now. Again, that will differ on a case-by-case basis, but may be something that you need to consider. And then a question that we're often asked is, well, okay, if we don't have a redundancy policy in place, and we're aware of all of the various policies that do need to be followed, but should we be looking to implement a specific redundancy policy ahead of running any redundancy rounds? And typically my view tends to be that if you don't have a policy in place, that's not necessarily a bad thing. They can be, as I say, quite prescriptive, and ideally you will obviously have the flexibility to follow what process is appropriate in any particular round that you're running, without being tied to specific periods of consultation, save for what you need to do from a legal perspective. So typically I wouldn't advise putting a policy in place if you don't have one already, unless there are particular considerations that make that appropriate. The other side of that coin might be that if you do have a redundancy policy in place and you're not thinking of undertaking any redundancy or restructuring exercises for some time, it might be worth considering whether that policy is in need of updating and reviewing. It might be that you get pushback from, for example, the trade unions if you're looking to, for example, make it slightly more flexible than it is at the moment. But again, it's something that's worth considering if it's something that might be getting quite some use over the coming months and coming years. Judy, I think you were going to talk about equality next.
Yes, thanks, Abisola. Yes, so in terms of equality in this context, of course, you will always need to keep equality considerations at the forefront of your mind in any redundancy and restructuring exercise. By, for example, ensuring that you avoid discriminatory selection criteria and ensuring that employees who are absent from work don't miss out on anything in the process, particularly around consultation and opportunities that arise from that, specifically, for example, where they're absent due to maternity or perhaps on sick leave due to a disability-related matter. But this morning, I just want to focus and highlight for you a change in the law that is coming into force from the 4th of April, which will extend the period in which certain employees have a priority right over other potentially redundant employees to suitable alternative employment. So currently, as you know, employees on maternity leave, shared parental leave and adoption leave have a priority right to suitable alternative employment. From the 6th of April, that's going to be extended so that they also have a priority right for specified periods after their return to work. Those extended periods are actually very significant. So I'm not going to go through all the way that the different periods work and are set out. We do need to look at that carefully because it's slightly different for the different categories of staff that are identified. But for example, a parent taking at least 6 weeks of consecutive shared parental leave will have a priority right to suitable alternative employment if they're facing redundancy for 18 months after the start of their shared parental leave. Similarly, a pregnant employee who takes maternity leave has a priority right to suitable alternative employment for 18 months from the point at which the pregnant employee has notified her employer off the pregnancy. No, sorry, after the date of birth. That's my mistake. 18 months after the date of birth. So just thinking briefly about what the key implications of that are for you. So first point to make is this is not a ban on making employees redundant who are in any of the protected categories. It simply applies to the right to suitable alternative employment. It is important to note that the penalties of getting it wrong in terms of priority rights here are high, because if somebody is dismissed when they should have been slotted into alternative employment, they can claim automatically unfair dismissal, which means that there's no qualifying service period, and also there's no cap on the maximum compensation that can be awarded, and further there may be a successful discrimination claim. So on that basis, quite clearly, you do need to make sure that you're fully aware of this change if you've got any restructuring or particularly redundancy proposals on the horizon. And you should ideally make sure that you've got up-to-date records about when people are going on, have, etc., the various types of leave, and make sure that you've got a system in place to monitor and check on what may be suitable alternative employment. Clearly it is likely that there will be many more employees with priority rights to suitable alternative employment in these circumstances. And, there is the potential for a situation to arise where you have more employees with a priority right than there are actually suitable vacancies. There's no guidance on exactly what you would do in that situation, but it looks like what an employer would have to do is to apply a sort of further selection process to identify who should get the relevant job. I think that if I have a crystal ball, I'd probably also predict an uptake in people taking shared parental leave, because particularly in times of economic uncertainty, when employees are aware that there may be necessary cost-cutting exercises, there is a certain attraction in acquiring these priority rights for themselves if a redundancy situation arises. I think there's also something around manager training to make sure that managers are aware of this and can handle situations appropriately, and also be aware of the rationale for this change in the legislation, as it may feel unfair to some employees. So that will require careful managing. And on that note, I think that Abisola is going to talk to us about the role of trade unions in this context.
I am. And this is a fairly short one, but something which I think is important to consider, and that is, to what extent are you going to engage with your trade unions, and when are you going to start that engagement process? You will all be very familiar with and used to consulting with your trade unions on a range of matters, including redundancy and restructuring exercises. But I think that we tend to find that depending on the scale of and the type of redundancy or restructuring exercise that you're undertaking, that might inform the approach that you take. So clearly there will be certain circumstances in which you're legally required to engage with your trade unions and consult on proposed redundancies, most notably in respect of any collective consultation obligations if the relevant numbers are reached. And that will, of course, determine the period for which you have to consult before the first dismissal takes effect. But even in circumstances where, again, you're making a relatively small number of redundancies, or certainly under the threshold for collective consultation purposes, it may be that your collective agreement or recognition agreement has an expectation that you will consult with the unions in respect of any proposed redundancies. Again, depending on the specific collective agreement or recognition agreement, it might be specific as to specifically what you're consulting on, whether that extends to selection criteria, for example, the business case. But I think even putting all of that to one side for a moment, it may be that irrespective of what you're required to do legally or under your relevant documents, you do need to give thought to, as I say, to what extent you are going to consult the unions. I know that there are certain decisions which institutions may be more reluctant to accept or concede are topics for consultation. So it may be that, for example, if you're looking at closing a course, it may be that you're clear with the trade unions in that circumstance that you're consulting on the proposal or any proposal to make redundancies arising out of that course closure, but that the course closure itself is a business decision which isn't the subject of consultation. It may be that in other circumstances you're slightly more open with the unions and seek to consult them on the business decision. I'm not going to try and suggest which cases would or wouldn't be appropriate for consultation in this particular context, because it will, as I say, differ on a case-by-case basis. But I think sometimes tactically, it may be that if it's a particularly contentious situation, there can be value to consulting the trade unions quite early and on certain substantive matters, if that's going to smooth the path for the redundancy or restructuring exercise and mean that there's less scope for getting sidetracked with particular issues that may arise from an industrial relations perspective. So that's all Judy and I wanted to cover in terms of those 5 key topics. I can see that there are a couple of questions in the chat, and we do have a couple of minutes to answer those quite quickly. Judy, I can see that there's a question on the topic that you were covering around priority rights. I don't know if you want to take that one. So the question is, does one group have a higher priority than others?
Yeah, thanks. That's no problem. So that's an excellent question. Does one group have a higher priority than others? So in that specific context of that, the new legislation on the right to suitable alternative employment for employees on and returning from the specific types of leave that I mentioned, no, that legislation doesn't identify any higher priorities or ranking within those groups. So I think the thing is, if you've got sort of effectively competing individuals for suitable alternative employment who are within those groups, you're going to have to do a form of selection exercise applying fair and non-discriminatory criteria. Not necessarily straightforward, I appreciate. There's also a second really good question, which is, does the new legislation up to 18 months after the birth trump a disabled employee for redeployment? Excellent question. Also a really difficult question, because the legislation doesn't tell us the answer to that, and there isn't really any case law to help us. I think you'd have to be extremely careful if you're faced with that situation, because you will have employees coming from different bits of the legislation who have the potential to bring claims for discrimination claims for uncapped compensation, etc. So I think you need to look extremely carefully at the circumstances, and I would suggest, and this isn't just me seeking more work, but I would strongly suggest, if you're faced with that situation, that you get specific legal advice, because that's particularly tricky. And those are the questions, Abisola.
Thanks, Judy. And so we're finishing bang on 10:30. So thank you very much for joining us all this morning. We hope you found the session useful and informative. Just quickly before we let you go, I just wanted to mention an upcoming webinar that we've got on immigration changes, which I imagine will be very useful for a lot of you. So that's due to happen on the 19th of March. So please do look out for the invites for that. Or alternatively, please have a look on our website to find the sign up link for that. But as I say, thank you very much for joining us. Please do feel free to contact either me or Judy with any other questions that you've got arising from this, or anything else that you want to discuss. And it's been good to speak with you all.
Thank you. Goodbye.
Bye.